Now, there has been a lot of hula baloo in respect of a designer that replicated a design which was custom made for her customer. Now, in Nigerian legal system, fashion law is still a very novel aspect of the legal law, and so many persons do not know or understand that when a designer or when a person wants a custom made design and does not want it to be replicated, certain actions can be taken legally against you where you replicate that design without the consent of the original owner of that design. Now, what are the laws that protect issues like this? We have number one, the Copyright Act. We also have the Patent and Designs Act, and we also have the Trademark Act. These are laws already stipulated in Nigeria that protect people from getting into issues such as this. When there's a dispute, we always resort to this act I mentioned earlier. Now, as a person who wants to sue for a design which you made and which you did not want it to be replicated, there are certain things that the law would look out for. Now, the design should not be a design that should will have been made in a commercial, in a large scale. It's not to be used for, not to be as a model for commercial purpose or for industrial manufacturing, because obviously you cannot have control over something that was intended for a very large scale of production. Now, where you want to, as a person or who is aggrieved because of the fact that a design you made has been used without your consent. Now, we have something called intellectual properties agreement, right? Where both of you would execute an agreement to the effect that where you make this design, because it's a custom made, before the person will make it maybe for another client or you know for a commercial purpose, the person has to have a written consent. But where this is not done, it should, because I mean oral agreements cannot be just you can an implied agreement cannot be very, very weighty when it comes to the court of law. But if there is a written agreement to the effect that this design ought not to be created for the market, right? You can have a very, very good grounds for a good case. Now, what are some of the things that the court will look at where deciding issues such as this? The court will look at the sophistication of the design, sophistication of the products or the materials used to make the product. Like, for instance, let me just use this instance. The issue on the internet right now, you could see that the design was actually made using exactly the same quality of material and the same design, right? If it had been altered in a certain way, there could have been a sort of way to cushion the grievance of the owner of the custom made dress, right? Also, the court will also look at certain marks. Is it a distinct mark that it would show that, okay, this is a mark that has not been created before? Is it a new design that has never been created before? The court will look at certain things, like I was saying earlier, of things such as the strength of the trademark in question. Now, if this mark has not been used before, right, it's not in the public, it has never been in the public domain, you have a good case, right? Also, the court will also look at things such as evidence of bad faith. Now, for instance, where you're doing this in bad faith, the court would always look at it, right? The court would definitely tilt to the favor of the claimant. And also, things such as the quality of the product. Yes, the quality of the product that was used, the quality of the materials that were even used for the product. If there's a similarity in it, this can give a very, very good backdrop for a good case. So when next things like this occur, you understand many fashion designers, yes, especially in Nigeria, replicate people's designs, right? It's done a lot. But ignorance of the law, they say, is not an excuse. So when things like this happen, you get to learn from issues like this, because if we could see from the issue of the case between Iniedo and the other lady, you just will see what happened in the case, because she had registered the trademark already. She was able to win in that case. Now, it's also good that before you engage in things like this, register a trademark. For instance, now you have a business name, you have a distinctive color, maybe in respect of your product, and you do not want somebody else to go and use that distinctive mark or color or whatever. You can register it as a trademark. There, no one can go to use that mark any longer, right? And anyone that wants to use that mark would have to pay to have it used, right? So these are some of the issues that come up. I hope you've learned a thing or two from this thing and know how to handle cases like this. Let in final note, even in a corporate setting, for instance, I love corporate a lot. Now, even in a corporate setting, for instance, if a person, an employee, is bringing in a new or novel idea, there are certain things that we'll talk about this later some other time. Thank you very much. My name remains Esther Aka, your corporate legal practitioner. Thank you very much. Bye. Have a beautiful weekend.